Supreme Court filing clerks are federal judges with authority to rule on petitions and motions. So if 6 Republican justices select 10 Republican deputy clerks, the real majority is 16-3. For example, suppose you file a supplemental brief, citing 2 intervening legal events on its cover consistent with Rule 15.8. The deputy clerk has discretion to read the brief and make the ambiguous legal determination of whether the arguments are relevant to the intervening events and choose to reject the brief. This even though Loper Bright v. Raimondo says making such disputed legal determinations of what the relevance of the arguments is, concrete disputes with consequences for the parties, is the proper and peculiar province of the courts, not administrative clerks not even vested with that authority by Congress. Suppose you then file a motion for leave to file the supplemental brief, to argue the arguments in it are relevant to the intervening legal events which are relevant to the issues of the case. This non-dispositive motion was filed on 8.5 by 11 paper, Rule 33.2 as specified in Rule 21.2c, and only needed on its face to argue the brief raised relevant issues surfaced by intervening events. The deputy clerk has authority to deny the motion without presenting it to a judge by using the false color, lying, that it violates some formatting rule. The clerk has no authority to rule on motions in 28 U.S.C. 671, not any more than a Colorado court can keep Trump off their presidential ballot according to congressional creation doctrine. But clerks are governed by politics, just as federal district judges have discretion to accept false hearsay as true and reject true sworn facts as shotgun pleadings, to give any politically expedient outcome the appearance of law. Suppose you then file a petition for a writ of Mandamus to compel the clerk to present the motion to an actual judge, to exercise his jurisdiction pursuant to 28 U.S.C. 1651. The clerk can rule on the petition, saying that he is the judge and so cannot be mandated by one, and lying that he cannot accept petitions which the rules don't specifically enumerate. The Judiciary Act of 1789 and 28 U.S.C. 1651 allow any petition necessary for actual judges to exercise their jurisdiction. Lord Mansfield codified Mandamus as a catch-all when there is no other specific legal remedy. The clerk claims he is not such a person holding office under the authority of the United States, but an actual justice, despite 28 U.S.C. 671 saying checks to the clerk go straight to the U.S. Treasury. Supreme Court deputy clerks can rule on and reject any case or motion without even filing it, whether for political ideology or convenience, without authority to do so created by Congress, using false color of some rule. Big surprise this would be used to abdicate jurisdiction under the Ku Klux Klan Act, so that executive branch actors at the state level can do whatever the mob wants to you, without a witness or jury trial.